DMV this morning, and I sent off the documents to child support like a couple of weeks ago, and I haven't got back the certified mail things.
How did you execute the certificate?
The certificate.
Yeah.
Yeah. You mean
the assumed name certificate that they're talking about in the statutes? How did you execute it into the case?
I took everything from the newspaper and everything, the register of deeds copy that I submitted to them, and put everything together.
Did you use their templates that they provided right there in the statutes?
The template in the statutes?
Yeah, in the statute. What you just said, what you emailed me, there's a template right at the bottom down there. 66-71.11. It says forms. It's got exactly what needs to be put in the used as assumed name certificate for your state. That is. This is North Carolina, correct?
Right.
Yeah, I could tell by NC and I could tell by what's written in the code. It's North Carolina.
Yeah, I did that. I did that one. 6671-11. I did
right,
that one.
Right, and you signed it. You recorded into the Register of Deeds office according to these statutes.
Yes, I did it.
Now, did you get a certified copy of it?
Yes.
Okay, and then how did you file it into your court case? How exactly did you file it into the court case?
I had to email it to them because they wasn't seeing people in person.
That's where you fucked up at. You can't email nothing to file no case. That's not how that works. You got to file certified copies. You can't email a certified copy to anybody. A certified copy is the wet ink. That's wet ink signature. That's wet ink stamp.
Okay.
That's why you can't mail an affidavit to anyone, because you need a wet ink signature. And that's the only thing you can file into a court case is a wet ink signature. Like certified copies or original copies. That's all you can file in a court case. You can't email anything to somebody to file into a court case. That's why your shit didn't work. You got to do this shit. You got to literally a hard copy that's certified or either original. You got to file it into that court case. And I would do it a court using. Let me see if I can find North Carolina Rule 12B. No, I think it's 60B. Let me see. Rule 60, North Carolina. Let's see what's going to show me. I'm Googling it. Okay. Yeah. Rule 60, when you're talking about Rule 60, that's relief from a judgment or order. If you type in, if you go into your Google search, and you type in Rule 60, North Carolina, put that in your Google search, and it'll show you exactly how you need to, how it basically says relief from judgment or order.
Right, relief from judgment or order. Clerical mistakes in judgments, orders, or other parts of the record, and errors therein arising from oversight or omission may be corrected by the judge at any time on his own initiative or on the motion of any party.
Pause. Or on a what?
Or
the motion of any party. And after such notice, if any, as the judge orders. See, that's on a motion. You need a motion. You got to file a motion into that court case with a certified copy of your certificate. You need a motion to do that. Most people tell you don't use a motion. Don't use a motion because you're asking the court. If that ain't the dumbest shit I've ever heard in my damn life, because they're telling you not. They're provoking you. They're discouraging you from using the process that's laid out for you in order to win your case. You need a motion. This right here is Rule 60 tells you how to be relieved from a judgment or order. Okay. Now, it says by order, by motion. So on the motion of any party, and after such notice, if any, as the judge orders. Say during the pendency of an appeal, Such mistakes may be so corrected before the appeal or docketed in the appellate division, and thereafter, while the appeal is pending, may be so corrected with leave of appellate division. B. Mistakes, inadvertence, and excusable neglect, newly discovered evidence, fraud, etc. And it says on motion, there it is again, on motion and upon such terms as are just, the court may relieve a party or his legal representative, meaning your attorney or somebody or whoever's representing you, from a final judgment, order, or proceeding for the following reasons. Number 1, mistake, inadvertence, surprise, or excusable neglect. That's 1. Number 2, newly discovered evidence, which by due diligence could not have been discovered in time to move for a new trial under Rule 59B. Number 3, fraud. Say wherever, heretofore denominated intrinsic or extrinsic mistake. Not mistake, but misrepresentation or other misconduct of any an adverse party. Number 4, the judgment is void. Number 5, the judgment has been satisfied, released or discharged, or a prior judgment upon which it is based has been reversed or otherwise vacated, or it is no longer equitable that the judgment should have prospective application, or 6, any other reason justifying relief from the operation of the judgment. Okay, you're gonna use one of those that's gonna fit your situation. You know what I'm saying?
Right.
And then you have to make sure you're explaining in that motion why you're attaching that certificate. What is that certificate doing? What purpose is it supposed to serve in that case? What is it proving? If you're stating something, your evidence is supposed to back up it's supposed to support what you're stating in that motion.
Right.
Okay? So, so for one, the certificate confirms that you, the living man, is not that corporation. Is not that all caps name. You're not one and the same. Number 2,
right.
I don't know what you stated in there, but I stated in mine. I know I stated in mine that I was the grantor and the grantor / beneficiary of that name. Okay, so
right.
I would make that statement and see if I would make that statement in the motion. I'm the beneficiary of that name, and so
right.
And you're the one that controls that name. You're the one that's doing business in that name. You making these statements, and you have a certified copy attached to it as Exhibit A to prove what you're saying.
Okay.
Evidence is what wins cases. Okay,
right.
So just making empty statements without any evidence attached to it, no affidavits with witnesses, no witness statements on, affidavits from any witnesses. You really it's hearsay.
Right.
Okay. So you're speaking those things that you need to speak in that motion. And your certified evidence is actually what's backing you up, and that's how you'll get your relief. You know what I'm saying? But you have to do it by motion. We told you twice in the same statute on a motion. You have to use a motion to do that.
Okay.
It's going to motion the court to get rid of it.
Now they should have the same rule for Ohio. This case is in Ohio, right?
Is it in Ohio?
Yes, it's in Ohio.
Okay, you should have been registering that name according to the Ohio statutes.
Registered according to Ohio in North Carolina.
Because you're doing business in Ohio. If that's where the case is at, that's where you're doing business.
So registered at the deed in North Carolina or Ohio?
No, I'm telling you, if the court case is in Ohio, then that's exactly where the business is being conducted, in Ohio.
Okay.
Okay, that's a different jurisdiction from North Carolina. That's two completely different. Keep in mind, each state is like a country within itself.
Yeah.
With two different jurisdictions. So you want to register it according to the statutes in the state where the court case is at.
Okay.
Because that's where you're conducting business. You're conducting business in Ohio right now, and that court case is taking place in Ohio. Keep in mind, every court case is nothing more than business. It's a business transaction.
Right.
So if you're conducting business in Ohio, that name needs to be registered in Ohio, according to the Ohio statutes. Look up the Ohio statutes and see how they require you to register that name. And
okay.
then you would use Rule 60, Ohio.
Yeah.
And most
Ohio,
likely, Rule 60 in Ohio is likely going to say the same thing.
It does. I'm looking at it.
Yeah, but I would use their codes according to their rules. I would use the Ohio codes. I wouldn't use North Carolina codes in Ohio and for a court case.
Okay.
Make sense? You got a court case that takes place in Ohio. You don't want to be using North Carolina statutes in your paperwork to file into an Ohio case.
They're going to kick back that last stuff I sent in because I did it for North Carolina.
Well, they ain't gonna kick it back. They file it right. They might file it right in there, but that's the reason why they still railroad you. It's two different jurisdictions.
Okay. Yeah, because they did this morning. I went to the DMV and I found out that I was supposed to send my driver's license again.
Right.
So I might have to make some payments, or they could take this stimulus check or something. But they want 3 full payments to reinstate it.
Mm-hmm.
And then the DMV up there in Ohio wants $50, and then North Carolina, they issued my driver's license. They just give me an important notice to call Ohio DMV to resolve the problem, and the problem was child support.
Right.
Yeah.
Right. Mm-hmm. That'd be something else. Well, that's exactly how I would go about doing it. You know,
okay.
I would definitely do it in the state where you're actually having the court case at. You can't use North Carolina statutes to enforce anything in another in Ohio jurisdiction.
So the motion, I would only need one motion to file into the case, not.
Right. But I'm just saying, but a certified copy of your evidence needs to be attached to it as Exhibit A. To prove what you're saying, a motion should be supported by an affidavit or some type of evidence to back it up.
Okay.
Most people file motions with it's just a motion with nothing attached to it. And if you do any deep research on motions, generally they're supposed to be supported by an affidavit. And keep in mind, you know, it's supposed something sworn. You know, it's supposed to be supported with some evidence. Most people never support anything. They never attach nothing to it. They just file it in there and wonder why it gets denied.
What do they be? What do they like when a person files it without evidence? What impression are they under? Like because they're not. Is it that they don't have all the information to file it? They're not.
It's just you can't move the court without you got to be able to you got to prove what you're saying. Evidence is what wins cases. That's what gets them to move on your behalf. But if you're just stating something like you're just stating something, and like even an affidavit, I even encourage people when they're using an affidavit. I would always encourage people to have 2 witnesses, because 2 witnesses are signed under penalty of perjury that the contents in that affidavit is fact.
Right.
Because according to the maxim of law, every word shall be established by 2 or 3 witnesses. That's even Bible scripture. That's why they use the Bible in the courts. There's Bible scripture and it's a maxim of law.
Right.
Every word should be established by 2 or 3 witnesses.
I made that statement. I got that statement that you were saying as the where I'm the beneficiary and the
grantor.
The grantor. I did that. I have those statements. Only thing I did wrong is didn't file it with Ohio Register of Deeds, and I didn't do a motion.
And that's all you got to do. Exactly. So you got to go into the Ohio statutes and say, well, about the assumed name. They may call it an assumed name. They may call it a DBA. They may call it a trade name. They may call it what else? Well, there's 4 different things they may call it: a DBA, trade name, assumed name, and what's the other damn name? It comes to me when I ain't thinking about it too damn hard. But it's 4 different things they may call it, you know. A fictitious name. Fictitious name. So they're just gonna call it one of those 4. So each one, all 50 states, they're gonna call it whichever one of them they're gonna call it. And so you're gonna register according to their statutes and what they require you to do. And not all 50 states use the same strategy. All of them have their own process. Yeah. Some of them are similar, some of them are exact, and some of them are different. So you have to read the statutes and see what they say.
I know they looking at my paperwork like, this nigga don't know what the hell he doing, and just threw my shit in the damn fireplace.
Well, yeah, you got first off, at first even what you filed in there was not certified copy. You emailed them something. That's not filing into a court case. That's not filing into a court case at all.
Well, the juvenile clerk, she was emailing me back and forth, and she was like, well, just shoot me your copies from the how did she say it? I had to scan it to her and stuff, because she was like and I sent her everything, the affidavit, the newspaper article, and the copies, or the original. I scanned the originals from the Register of Deeds.
Right.
She took them and stamped them, and then she sent them back to me with the stamp on them, the time stamp. But I don't think I did a motion. I don't think it was a motion.
Well, that's a copy, but it's not a certified copy. That's for your own records. She sent that to you for your own records. But that's not a certified copy. She just, that's proof that you actually might have filed it, but you want to, but at the same time, if you want a certified copy filed into your court case, and then you have to have that's a totally different thing. She just gave you that for your own records. But that's not a certified copy. That's a regular copy. That's a regular copy. A certified copy, like if you go to the Register of Deeds office, wherever you file your documents into your court case, and you want a certified copy or something, they print it out. What they do is they stamp it. They stamp it with this it's like a pre-written stamp. They have to fill in the blanks on it, basically saying that this is the certified, that this is a true and correct copy of the original. You know what I'm saying?
Right.
And they'll sign it. They'll sign it themselves. You know what I'm saying? That's basically that's going to be proof that is actually an actual record, and it's from their office. It's from their records. You know what I'm saying?
Yeah.
And then that's what makes it admissible evidence. You know what I'm saying? So when you did your certificate of assumed name, you didn't, you needed a certified copy so that you could file directly into that court case.
Okay.
So that's when it would have been admissible evidence. But just a regular way. Yeah. So because they can only file only thing you can file into a court case, it has to be either original or certified copy of the original. Not just a plain printed out copy that printed off the internet. You know what I'm saying? You can't do that.
Well,
otherwise, they'll let you. Some of them just might let you slide and do it, but it won't move to court because it's not a certified copy. Because I used to do certain stuff like that with the Constitution. Back when I first started with my child support case, because I was filing all kind of bullshit in my court case. But for the most part, they would let me file it because they realized I wasn't doing but just filing shit in there. Some of the stuff they just let me file in there, but I wasn't moving to court at all. I couldn't get them to do nothing.
Right. Yeah.
And I was wondering why. Evidence is what wins cases, but you looking. I forgot what rule that is where it talks about admissible evidence. Let me see. I'm gonna find that.
So you suggest that I take another trip to Ohio again? I got to go back up there, right?
You can probably you might can do that. I don't know. You have to read their statutes and see what they require you to do first off. And you might be able to get it done from where you are. There's no telling. You got to read the statutes and start with the statutes and see what they require first.
Okay.
Yeah. Yes,
Okay.
admissible.
I got Rule 60 pulled up, and I got to print off the papers for the assumed business name in Ohio,
Right.
and start and register that my evidence with them first that I got,
Mm-hmm.
and then I can get that motion printed off.
Right.
And then I'll have to. How would I get the clerks to give me that wet stamp from here?
They'll have to mail it to you.
Oh.
Yeah, they have to mail it to you. You have to pay for it, but they'll mail it to you.
Okay.